So I just wanted to start by saying that I can relate to the work that you're doing because as part of the OpenNet initiative, I actually did field work in a couple countries, including one where if the field work had been detected, it might not have gone particularly well for me. And so I thought it might be helpful. This series has a really terrific diversity of expertise and also of recommendations, including a lot of really worthwhile technical recommendations, but we're going to start by talking about what computer scientists call the threat model. In other words, what is it that you're worried about? And so we're going to assume that no matter how good the precautions you've taken are, that there's an adversary out there, whether it's a government or whether it's a private actor, that is sufficiently smart, capable, and determined that your online anonymity or pseudonymity or security has in some way been breached. And that means it's important to understand the legal risks that you might face and the ways in which you can protect yourself. And I'm assuming you've already done things, right? You're using Tor, you're using Tails as an operating system, your phone is encrypted and has a really good password and not just a fingerprint scanner. It turns out that the police can make you put your thumb up against your phone to open it, but they're going to have to go to court and convince a court to get an order for your password. So the first thing I would say is, as they said in Indiana Jones and The Last Crusade, choose wisely. Some providers, such as Google, will force entities such as law enforcement to show up with a warrant, which is signed off by a neutral, disinterested judge, to access content such as your emails on Gmail, even though that's not technically required by law. That's the way that they interpret it, and some providers are much more willing to share information with the police. You need to know the difference, and you can find that out by reading boring stuff like the terms of service for your provider, and also by looking at entities like EFF that rate the privacy and security protections of different providers. Beyond that, it's worth knowing that there actually is a difference between the information that you post online and the information that's used to post it, such as your IP address and the way that it routes. And that information is much easier for law enforcement to obtain. It takes only something called a subpoena, which is essentially a form letter that a judge's clerk signs on the request of law enforcement. So this is why it may be helpful to use things like Tor, is that if you send a message from your home computer, it's very easy for it to be traced back to you. If you use Tor or a publicly accessible computer, it's much harder even if somebody does go looking for that much more readily accessible information. It might also be worth talking a little bit about sort of some of what the legal risks are in what you post. And so a couple rules I wanted to talk about. The first is that there's always the threat, if you are talking about anyone from a political figure to a corporation, that you're going to get in trouble for what's called defamation. Defamation is basically a statement that's untrue and that hurts the reputation of someone. And the basic rule here is that opinions are protected under the First Amendment to the U.S. Constitution, which guarantees free speech, but false statements of fact are not. So to give you two examples, the first is if you post after watching this video that Bambauer is a jerk, you are completely protected. No court in the land will allow a lawsuit against you. On the other hand, if you say Bambauer is a criminal, you will probably be called to account for that if you get sued because it's a much more factually verifiable statement. And there are some things that seem like their opinion that some courts will take as facts. A great example from the short-lived court case of Cohen versus Google in New York State Court involves a dispute between rivals, one of whom was a fashion model, one of whom blogged about the fashion industry. The blogger started a blog called Skanks of New York City and referred to the fashion model as New York's skankiest. Well, that's probably an opinion, but she also called her a hoe. And so when the fashion model went into court, she said, that's defamation. And why? Because it's defamatory to call someone a criminal, and the judge said, you're right. Accusing someone of being a hoe means accusing them that they're a prostitute, and so she was able to uncover the information from Google that led to her being identified publicly. So it's worth knowing just a little bit about this weird area of law. It's also worth understanding that, on the other hand, you actually have some unusual protections for organizing online. Let's say that you run a website and you allow comments to posts. and someone posts something that's defamatory or otherwise problematic. It turns out that as long as you didn't write that post and you didn't tell the person to write the post, you're safe under a little-known area of telecommunications law, which we lawyers shorthand as Section 230 of the Communications Decency Act. That means that no one gets held liable for something that someone else says or that you happen to publish that someone else says. And this is a not well understood but very potent defense that everybody who works online or who runs a website or a web host ought to know just a little bit about. So I want to close just by talking about the fact that lawyers tend to approach the world as though every problem is legal, when all you have is a hammer, everything is a nail. But it's worth noting that there are a lot of other ways that powerful parties such as governments and large corporations can put pressure on online activists, what I call soft censorship. And you might look into the history of the sort of campaign against WikiLeaks in this regard. Its payments were cut off by the payment networks. It got bounced from its domain name service provider here in the US, not because it had necessarily violated any law, but just at the kind of request of the US government and US officials. And so if you have a YouTube account and there's a complaint, it can be shut down and you don't have any legal recourse. You can ask Google, but it's up to them whether to restore it. There could be reputational consequences. They can go to your employer, your friends, your family, your school to put pressure on you. You may get harassed by law enforcement. You may be subject to trolling or doxing. And this is one of those areas where the online and the offline blur. If someone observes you taking a video of a rally or a protest, and then they notice that that video is uploaded to YouTube under your pseudonym, they may be able to make the connection. So it's worth thinking about the ways in which your online and your offline identities are linked. And so let me close by saying that it's hard to get reliable legal advice online. And so I want to just point out a few sources that some of you will know, but some of you may not. The Electronic Frontier Foundation, a famously zealous and effective defender of online rights. The group FIRE, which supports freedom of information in education. The ACLU, including not just the national branch, but your state and local chapters. And then lastly, if you run into problems, look to your local law school's clinic. A lot of clinics will represent activists and other sort of socially conscious organizers for free. And it can be a wonderful equalizer when you get a scary letter in the mail or a knock at the door. So thanks for having me. I'm delighted to be a part of this.